Thank you very much. Welcome to Court Helicopter News. Every weekend where we bring to you an explainer that gives you the insight of what actually is the law and not what people talk about on the streets or in the village. The question we are looking at is, this is the episode number 2. We are dealing about the law of succession. This is the law that deals with you when you are dead. How will your body and how will your property be dealt with? 2, as a child, as a daughter, as a wife, as a spouse, when yours truly goes, he's dead, he's buried, how do you deal with the question of the property that yours truly had? So today, we shall be dealing with that question under Cap 160 of the laws of Kenya. That is the law of succession. There are 2 ways to deal with the property of a deceased person. One is what we call the testate type of succession. Testate means there is a will. He or she decided to write a will, and you cannot go against that will. That is what we call testate succession. The next one, in the next episode, we shall be dealing with the question about if somebody dies without a will, if somebody dies without pronouncing if somebody dies without pronouncing himself or herself on how the property will be dealt with. That will be the 3rd episode that we shall look at. So today, let us deal with the testate succession. This is where somebody has drafted a will. What is a will in the meaning of the law of succession? This is a written document that explains the wishes of the dead person. The wishes are normally in 2 issues: about the disposal of his body and the remains, and 2, how the properties he or she acquired shall be distributed according to the late person's instructions. So the first thing in the will, the first element that comes into section, that is section 5 of the law of succession, is capacity. Who can do a will? 1, the person who is writing a will must have capacity. Capacity under the law is 1, he's not a child. Anybody below 18 years cannot write a will. 2, anybody who is mentally retarded, completely mentally incapacitated, due to 1, age. The older people are, they have a disease called dementia, they will not do a will. 2, due to the ailment, somebody is completely incapacitated in hospital or at home due to the chronic type of disease that person is having. So that person cannot make a will. 3rd, the level of drunkenness. If somebody will be proved that by the time he was doing the will, he was completely drunk, he did not have the capacity to do that will. He can't make a will. 4th, if that person at the time of doing the will, he was under certain conditions, either he was a hostage, it was at gunpoint, it was fraud, it was coercion, it was pressure exerted on that person will not have capacity. Therefore, Section 5 says that the person must be of sound mind and an adult, and that person is able mentally to do the will. The wills can be revoked under Section 6, that is Section 7, if that will that person did is proved that there was fraud occasioned by that, or there was coercion, as I've said, that is being forced, or there was a mistaken, a honest mistake that will not be accepted as a will for the purpose of that will. The manner of doing the will. This is the procedure provided in section 11 and section 10 of the law of succession. 1, the person who is writing a will must come before somebody and give those instructions. You walk to an advocate, he drafts your wishes. After he has drafted your wishes, he takes particulars of you, who you are, takes your ID card, takes your mobile number, then says, these are my properties. You say, property LR to this goes to John, property XYZ goes to Mary, property this goes to... That are the wishes of the person writing the will. Number 2, after that has been captured, there must be 2 independent witnesses to sign as witnesses. These independent witnesses must be younger than the person who is doing the will, so that if the person writing the will is 90 years old, he can't bring a mzee of 120 years to witness him doing the will. The reason is that the witness might die earlier than the person doing the will. 2, the witness must be adults. 3, the witnesses must be, they themselves be of sound mind and the capacity to witness this. And lastly, they must sign what they are witnessing. Remember, the witness does not need to know what the content of the will. So they don't read what the person doing the will is. Theirs is to witness him sign, and they confirm that. That is the role. That's what is called attestation. Number 2, the person doing the will must sign that will. If the document has 6 pages, that person must sign every page. He will put his name, he will put his fingerprint. If he is not able to sign, he will sign, and he will put the date and the ID number there. That in the presence of 1, the advocate who drafted, in the presence of the 2 witnesses or 1 witness. Another witness can come another day, but there must be 2 witnesses that are independent. 3, in writing a will, a witness cannot be the person who is going to benefit. You are the man who is dying. You are writing a will, and you have been taken by a second wife, a side woman. Then she witnesses you transferring all the properties to her. That is a ground to nullify that will. So the beneficiary should not be a person who is the one to witness that will. The will be kept by the advocate in an envelope that is sealed. That will only be opened after a person has died. And normally, immediately after the person has died, the advocate will call those close family members and open the will in their presence and read the will to explain how somebody the deceased wanted his body done away with, and how he has provided for who should get what that person is. A written will is not a permanent will. That is what we are looking at section 19, that you can revoke a will that has been written. How? The will is revoked by another will. if I wrote a will in 1920 and I do another will in 1950, the will that will be taken to be the final will is the last will. So people continuously write wills and change those wills. The reason the property that you owned today might not be the property you will have next week. So if you sell the property that you had given your daughter or your child, you'll do another will that now brings in the new property that you have acquired. And if you change your mind, you had given Evans this type of property, but you say, no, Evans has become a problem to me. You say, let me change now. I give it to somebody else. The will is not permanent. Anytime a will is written, it revokes the will of the other person. Let us conclude this question of wills that it is a formal way to control your property and to control yourself. If anybody is not happy with the will, then they have a right to move to the High Court to challenge the validity of that will. Either the procedures were not followed at the time of drafting the will, or two, the way the properties were distributed is unconstitutional or has discriminated somebody. So the will can be challenged on those grounds and be taken to court. Let us deal with the second type of will under section 910 of the law of succession. This is what is called the oral wills. A will can be written. We have dealt with the question of how a written will is done, and a will can be orally. This is what the law says. Anybody who makes an oral will, there are conditions that must be there. What do you mean? All of you sometimes have been called home. Come rush, your father wants to see you at this bed, dying bed, or your mother is very sick. She wants you in the village to go and see her. You get summons that all family members are required to attend to a deathbed of a patient who is very dear to them. And that person gives you it tells you, I think my health is bad. I have now accepted, I want a pastor to come and baptize me. Now, my days are over. But that cow, the black cow, I give you Mary. You, that dog that barks a lot, I give you Danstan. You, that car, KB something, I give you. So that is a will. What will the law say to make that oral will valid? One, there must be witnesses in that when he or she is dying and you have been called as family members, ensure there are two independent people who will see and hear those final words. They call it in Kiswahili wasia, wa mwisho. There must be witnesses. Two, the person who you have gone to see, that person who is dying, by law, he must die within 3 months. If he told you this story in September, by December, that person must have died. If he lives more than 3 months, that oral will has collapsed. You cannot go to court and say that my dad, before he died, he told us this last year. Get it clear. The person who gives an oral will must die within 3 months from the time he or she gave that will. But there is an exception. If the person who called and gave an oral will is a military officer, is a Kenya Army person, is a police officer who has gone to Haiti, that is, they are officers in a battle zone. They are fighting. death is always imminent, then to them it is called an oral will in contemplation of death. Them, there is no time limitation to those wills. So the oral will, which all of us know, and which is very contentious, I have provided for you how to deal with the question of oral will. That marks a dramatic end to our episode today on how do you distribute your property in terms of wills, either by oral will or by a written will. Continue watching every Friday, every Saturday and Sunday, Court Helicopter News, where we bring to you the latest provisions of the law without paying. Keep tuned and keep watching episode 3 coming shortly. Wakili Danstan Omari. Thank you.